thank you to Fulja and Matthias for organizing this seed policy talk and giving us the possibility to have an exchange on patents on seeds. I'm Johanna and I work for the organization of patents on seeds, and today I'd like to give you a brief overview of the problems that we are facing in regards to patents on seeds. I try to not make it too technical, but rather give a general overview. But nevertheless, I included a lot of information in the presentation. So you'll have information where you can read up on more details. And before we start to go into the technical details on patents, I'd quickly like to tell you what the Organization of Patents on Seeds is doing. We started already in 2017 as a coalition of many European organizations that saw the risks that were coming from patents that were granted on plants and animals derived from conventional breeding. So they joined forces and had big campaigns in regards to the European patent law and as well the legislation at the European Patent Office. And since 2018, we are a non-profit organization that is based in Munich. We are quite a small team. It's our expert Christoph Thien and me, and then we have a research team that is looking up all the patents that are being granted, and this is the very important work that gives us the information we need of what is indeed going on, what are the patents that are being granted, where do we see problems, and as well on the basis of that we annually publish a report where you can find detailed figures on the situation, and that is an important work because these figures are not that easily available and gives us a good basis for debates that we are then having on a political level, for example. At the moment, we have 15 member organizations from Germany, Austria, Switzerland, Belgium, the Netherlands, Denmark, and Portugal. And some of these member organizations are as well with us today. So you might have a direct exchange with them as well later today. And so the basis of our work is, as I said, the patent research that gives us the informations that we need to then have a good base to start our work and the reports that we are publishing. We then have regular exchanges with the experts that are working on patents on seeds. These are mainly the representatives from the member states at the European Patent Office. So there are 38 contracting states, and the representatives come from the ministries of the countries or from the national patent offices. And so we have established a quite regular contact with these people, and they get frequent updates, reports, analysis from us. And we have as well meetings with them. And then there are specific patent cases that we see as very problematic, so patents on conventional breeding, and we take those as examples to file oppositions and get them to be dealt with in front of the European Patent Office. And obviously we cannot oppose all the patents that are being granted on conventional breeding. This would surpass our capacities, of course, and that is not the idea. It's rather that we can show with examples what the problems are, and then make sure or try that the problems, the legal problems that are behind those patents being granted are being solved on a larger scale, so that we will not have the problem of those patent cases anymore. And to support the political and legal goals that we are having, that is no patents on plants and animals derived from conventional breeding. opposed to patents on genome editing. We are doing public campaigns and media work to try to influence policy and try to get politicians and the EPO to find solutions for this problem. And in this work, we have, of course, the support of our member organizations, but as well of many other partner organizations. So anytime you want to support the work we are doing, we always very much appreciate to get support of other organizations so that our voice gets stronger and it's easier for us to do something. And so we have a homepage where you find many resources on where to look up more in detail the debates about patents on seeds. So for example, the annual reports that I mentioned, where you can find exact figures on what patents are being granted. You find as well an overview of the legal debate of the last couple of years and the relevant documents that have been published. That is on EU level, but as well on the level of the European Patent Office. And you find as well examples of specific patent cases that have already been granted and an overview of what has been granted and what's the state of this patent is. So if you have filed an opposition, if there is a hearing planned, etc. And there is as well an extensive database, but this is only in German, unfortunately. So to give you a brief overview of the reports that we published this year. So, well, you can find, of course, the whole report following this link. And the most important things that I'd like to tell you that is being explained in this report is, first of all, the risks that patents are being, that patents have in regards to the work that our breeders are doing. So first of all, when usually a big company is granted a patent, it's a breeder does not have access anymore to the varieties that may be affected by these patents. And in general, it's very difficult for breeders to know which varieties are already affected by a specific patent. And that is, of course, a risk that we see for global food security and as well food sovereignty, because as you all are very well aware of, for farmers and breeders, it is very important to have access to biological resources so that they can then adapt the plants that they are working with to new conditions. May this be different climate conditions, new pests or diseases. And opposed to the plant variety protection law, when you have a variety that is protected by plant variety protection law, a breeder still has access to this variety and can then do further breeding and work with a variety and adapt it to the needs that he has and we as a society have. But with a patent, it is different. You cannot patent a variety, but specific traits or characteristics in a plant may be patented. And then if this characteristic can then be shown in sometimes 100 different varieties. So a patent is much more far-reaching than plant variety protection and is not suited as IP protection in regards to plants. And what we see at the moment at the European Patent Office is that the legislation is not clear, the wordings are not clear, and that is opening up legal loopholes For example, it is not clear the difference between genetic engineering, something that is regarded as a patentable invention, and conventional breeding that is regarded as not technical and not patentable, is not clear. And so, for example, random mutations are regarded as patentable, even though they're used in conventional breeding for a very long time. And it's as well not a very targeted process to in breeding, but you just get a big variety of mutations, and would then anyways have to work with crossing and selection. So methods of conventional breeding to obtain a specific characteristic. And big companies are misusing these loopholes, and we see in many of the patents that are being granted that they describe a conventional breeding method, but then introduce as well some technical steps to make it seem as though it is a technical invention. But these are usually steps that are not really necessary for the breeding process. So our political demand is that breeders should have freedom to operate, so they need access to biological material, and the access would be blocked by patents. So patents on conventional breeding should not be allowed. And there are some legal solutions that would be to have a clear definition of what is a so-called essentially biological process, so conventional breeding. And this as well, I don't want to go into too much detail here, but as well to limit the scope of protection. So what I said before, when, for example, a patent is described on a technical process, it should be limited to this technical process, but not extend as well to conventional breeding. And after this quite technical part, I'd like to go into a much more practical side and show you some clear examples of patents that have already been granted. And in general, you can say that per year around 100 patent applications on plants from conventional breeding are filed. That is, in the last 10 years, we saw about 1,000 patent applications. And of these, 200 patents have been granted. So it's not some theoretical problem, but we already have 200 patents on plants from conventional breeding. And some of these patents are, for example, a tomato patent by Syngenta. These were tomatoes that have a higher content of flavonols, so they are considered to be more healthy. And in this case, we had an activity where we involved people to sign this opposition, and we had 65,000 people filing this opposition together with us in 2016. And after that, in 2019, Syngenta withdrew this patent. So this was a big success for the work that we were all doing together. And another success was a patent on a so-called Indian melon by Monsanto. This was where an opposition was filed as well in 2012. And then finally the patent was revoked this year. But this shows you as well how long these patent hearings can take until a final decision is being taken. So the goal has to be to prevent those patents before they're being granted, because afterwards it's quite difficult. Then here are two patent cases in regards that are relevant in regards to climate change. It's a patent on lettuce that can as well be grown under hotter climate conditions, where we filed an opposition in 2019, and there is no hearing scheduled yet. and a patent on a soybean that is as well adapted to certain climate zones. And there was a decision, an opposition filed in 2017, and there is no final decision on that case yet. And the last two patent cases that we have going on right now is a new patent that has been granted this year on a watermelon that was found in a home garden, and that has a bushy growth, so it doesn't take up too much space, which is a good characteristic, a very useful characteristic. And so this is a patent very most probably going to file an opposition in this year. And in November 2021, a hearing on a patent on salmon will also take place. So just to give you a brief overview, and you can look up more details on these patent cases on our homepage. And then the patent that was promised to be talked about today is the patents on barley and beer from the companies Carlsberg and Heineken, where a hearing took place very recently. And these are patents that have been granted in 2016 on 3 patents that have been granted on barley from conventional breeding. And the patents are interesting because they cover the whole value chain, so to speak, of this plant. So the barley itself is being patented, the brewing process, and as well the beer derived of this barley. So it shows very well as well how far-reaching a patent can go, and not only cover the plant, but the whole value chain of this plant. And this is as well a case of a patent on random mutations. And one of these patent hearings took place in 2021, so very recently, but unfortunately the patent was maintained. So even though we argued that this is a patent on random mutations, and we had as well other arguments on a more technical level, the EPO confirmed that this patent will be maintained. So they are still granting and maintaining patents on conventional breeding. And this patent as well shows very well how these patents affect breeders. So we had a German breeder from Cultivari who was working with barley that was affected by another patent application of Carlsberg on a barley. They have a dozen more patent applications, so patents that have not yet been granted, but they have applied for more. And this breeder was very concerned because he saw his breeding work of the last 10 years being affected by the patent, and was not sure how this may affect his work, and if he could ask for plant variety protection for this barley. And even though this application was withdrawn by Carlsberg, it shows very well how difficult it is for a breeder to even get to the information to know in which aspect he can move with his breeding, so to say. So that is why he contacted us, and even for us it was difficult to find, for example, a laboratory who was able to analyze the barley and could tell us, yes, this patent will affect this specific barley variety or not. And this is why patents are severely hindering the work of breeders, even if when the patents are not even granted yet. But already before that, breeders see themselves in a very uncertain position. And Then lastly, I would give you a brief update on the German symposium that was taking place today. So of course we were as well for a long time in contact with the German ministry, and they we asked them always to get more active in regards for a clear prohibition on patents on plants and animals, since in the coalition agreement of the German government it is written that they are opposed of patents on plants and animals from conventional breeding. And quite late, but anyways, they organized this conference with different stakeholders like the European Patent Office, experts from national patent offices, farmers' representations. We as an NGO were part of it as well. And the discussion was very interesting, and it was good that we had the opportunity to discuss these issues. But obviously no solutions were found at this conference, and it only showed us that there are still open questions and legal uncertainties for all parties. So as well, industry wants clear regulations. They may have different goals than us, but they want as well clear guidance. And it was promised that there will be more discussions, but we do not only need discussions. We have discussions now for several years now, but now we would need concrete steps to continue. Yes, and since I already took up quite a lot of time, I would like to finish my presentation here. At the other slides, you still have a brief update on the legal background at the European Patent Office, and can look that up if you're interested. And I would rather stop now so that we then have enough time for discussions and your questions later on.